Okay, so babasahin natin ngayon ay tungkol pa rin sa political and international law, Bill of Rights. Okay, so letter A, due process. So let's discuss due process. So meron siyang procedural and substantive due process. So under the jurisprudence, the Supreme Court held that due process is comprised of two components. The substantive due process, which requires the intrinsic validity of the law in interfering with the rights of the person to his life, liberty, or property, and procedural due process, which consists of the two basic rights of notice and hearing, as well as the guarantee of being heard by an impartial and competent tribunal. So ano naman yung void for vagueness? So under this doctrine, for an act to constitute a crime, the law must expressly and clearly declare such act a crime. Yeah, period. Our related doctrine is that penal statutes are construed strictly against the state and liberally in favor of the accused. So let us compare administrative due process and judicial due process. So under the jurisprudence, the Supreme Court held that under administrative proceedings, the filing of charges and giving reasonable opportunity for the person so charged to answer the accusations against him constitute the minimum requirements in due process. Its main essence is the opportunity to explain one's side or an opportunity to seek a reconsideration of the action or ruling complained of. Judicial due process naman, under the jurisprudence pa rin to, the Supreme Court held the following essential requirements of procedural fairness in judicial proceedings. Number one, there must be a court or tribunal clothed with judicial power to hear and determine the matter before it. Number two, jurisdiction must be lawfully acquired over the person of the defendant or over the property which is the subject of the proceedings. Number three, the defendant must be given the opportunity to be heard. And number four, judgment must be rendered upon lawful hearing. Magtungo naman tayo sa letter B, equal protection. Yan. So requisites for valid classification. Equal protection ang pinag-usapan natin dito. So, under the jurisprudence, once again, the Supreme Court held that the constitutional right to equal protection of the laws is not absolute, but is subject to reasonable classification. Number one, it must be based on substantial distinctions which make for real differences. Number two, must be germane to the purpose of the law. Number three, must not be limited to existing conditions only. And number four, must apply equally to each member of the class. So ito yung tests ng valid jurisdiction. Letter C, magtungo naman tayo sa arrests, searches, and seizures. Okay, pinost natin pero it seems na lalong mag-iingay ang mga tikbalang sa ating kapitbahay. So i-discuss na natin. Number one, requisites for a valid warrant. Okay. Ano-ano yung mga requisites for a valid warrant? Letter A, under the jurisprudence to Letter A, it must be issued upon probable cause. Letter B, probable cause must be determined personally by the judge. Letter C, such judge must examine under oath or affirmation the complainant and the witnesses he may produce. And letter D, the warrant must particularly describe the place to be searched and the persons or things to be seized. Pag-usapan natin naman yung warrantless arrest and detention. So under the revised rules on criminal procedure, the parameters for effecting lawful warrantless arrests are, okay, letter A. Nalilito ako dun sa mga numbering dito. Ayan. Letter A, when in his presence the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Ito yung pwede yung warrantless arrest. Letter B, when an offense has just been committed and he has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. And letter C, when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment, or is temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. In cases falling under paragraphs A and B, the person arrested without a warrant shall be forthwith detained to the nearest police station or jail and shall be proceeded against in accordance with Section 7 of Rule 112. So kapag in the presence of the person in authority, Ayan, mayroong gumagawa ng krimen o nag-a-attempt o kaya naman merong isang naganap na opensa at may probable cause to believe under his personal knowledge na yung taong yun ang gumawa nun, ay agad-agad idediretso yung taong hinuli sa nearest police station or jail and shall be proceeded against it in accordance with Section 7, Rule 112. Ano naman yung Section 7, Rule 112 ng Revised Rules on Criminal Procedure? When a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation, the complaint or information may be filed by a prosecutor without need of such investigation, provided an inquest has been conducted in accordance with the existing rules. In the absence or unavailability of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly with the proper court on the basis of the affidavit of the offended party or arresting officer or person. Inquest is an informal and summary investigation conducted by the public prosecutor in a criminal case involving persons arrested and detained without the benefit of a warrant of arrest issued by the court for the purpose of determining whether said persons should remain under custody and correspondingly be charged in court. Yan. Yun ang inquest. Magtungo naman tayo sa number 3, warrantless searches. Third topic yan. Under the jurisprudence, the instances of reasonable searches and seizures are: so number 1, warrantless search incidental to lawful arrest recognized under Section 12, Rule 126 of the Rules of Court and by prevailing jurisprudence. Number 2, seizure of evidence in plain view. Ano ang elements nito? Letter A prior valid intrusion based on the valid warrantless arrest in which the police are legally present in the pursuit of their official duties. Letter B, the evidence was inadvertently discovered by the police who had the right to be where they are. Letter C, the evidence must be immediately apparent. And letter D, plain view justified mere seizure of evidence without further search. Number 3, yan. Search of moving vehicle when its transit in public thoroughfares furnishes a highly reasonable suspicion amounting to probable cause that the occupant committed a criminal activity. Number 4, consented warrantless search. Number 5, customs search. Number 6, stop and frisk. And number 7, exigent and emergency circumstance. So ano naman ang exclusionary rule? The principle which mandates that evidence obtained from an illegal arrest, unreasonable search, or coercive investigation, or in violation of a particular law must be excluded from the trial and will not be admitted as evidence. Yan ang exclusionary rule. Tungo naman tayo sa letter D, the privacy of communication and correspondence. Yan. Article 3, Section 3 of the Philippine Constitution, sabi niya, the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. So, suriin natin naman yung private and public communications. The privacy of communication shall be inviolable except upon lawful order of the court or when public safety or order requires otherwise as prescribed by law. So, under the jurisprudence ito, applying the US case of Whaler ba to? Versus Roe. The Philippine Supreme Court held that decisional privacy and information privacy involves the right to independence in making important decisions, while informational privacy refers to the interest in avoiding disclosure of personal matters. Informational privacy has two aspects. Yan. Dalawang aspeto ng information privacy: the right not to have private information disclosed and the right to live freely without surveillance and intrusion. Okay. So under the Cybercrime Prevention Act, the Philippine Supreme Court held that when seemingly random bits of traffic data are gathered in bulk, pulled together and analyzed, this would lead to creation of profiles of the persons under surveillance. So real-time collection of traffic data is not invalid per se. However, there must be robust safeguards and an explanation for the need and nature of the traffic data for warrantless real-time collection. Pag-usapan naman natin privacy in workplace under the jurisprudence. Isa ito sa mga pagkakataon kasing intrusion. Kailan ba siya allowed? So under the jurisprudence, the Supreme Court held that a search by a government employer of an employee's office is justified when there are reasonable grounds for suspecting that it will turn up evidence that the employee is guilty of work-related misconduct. Tungo naman tayo, under the Human Security Act, the law enforcement, upon written order of the Court of Appeals, may listen to, intercept, and record with the use of any mode, form, kind, or type of electronic or other surveillance equipment, or intercepting and tracking devices, or with the use of any other suitable ways and means for that purpose, any communication, message, conversion, discussion, or spoken of written words between members of a judicially declared and outlawed terrorist organization, association, or group of persons, or any person charged with or suspected of the crime of terrorism. So, ito yung mga special laws in relation to privacy of communication and correspondence ng Constitution, Bill of Rights. Under the Anti-Money Laundering Act naman, the reporting of covered and suspicious transactions to the Anti-Money Laundering Council is an exception to bank secrecy laws, and such transactions must be reported to the Anti-Money Laundering Council. Pag-usapan naman natin, intrusion may be allowed upon lawful order of the court or when public safety or order requires otherwise. So, exclusionary rule, applicable na naman siya rito sa pinag-uusapan natin. Any evidence obtained in violation of the privacy of communication and correspondence of the Constitution shall be inadmissible for any purpose in any proceeding. Pag-usapan naman natin, freedom of speech and expression, letter E. So, prior restraint. Ano ba ang prior restraint? It means preventing publication of speech before it is published by an injunction. As long as the speech is in a public forum, prior restraint is presumptively unconstitutional. The only way that this will be allowed is if the court agrees there is an imminent and compelling threat. So yun ang prior restraint. Ano naman ang subsequent punishment? It means punishing the purveyor of illegal speech after it is published through civil or criminal actions. Ano naman ang clear and present danger test? So under the jurisprudence, it is a test to determine whether the evil consequence of the comment or utterance is of an extremely serious and the degree of imminence is really high before the utterance can be punished. Ano naman ang content-based and content-neutral regulations? A content-neutral regulation is merely concerned with the incidents of the speech and merely controls the time, place, and manner of the speech under well-defined standards. A content-based restraint is censorship and is concerned with the content of the speech. So, ang content-based restraint is evaluated using the clear and present danger test. So, courts subject content-neutral regulation to immediate scrutiny. So, pag-usapan naman natin yung facial challenges and overbreadth doctrine. So, under the facial challenge, contends that the government law, rule, regulation, or policy is unconstitutional as written on its face. It is allowed to be made to a vague statute and to one which is overbroad because of possible chilling effect upon unprotected speech. Ano naman ang overbreadth doctrine? It is an exception to the prohibition against third-party standing. It permits a person to challenge a statute on the ground that it violates the free speech rights of another, even though the law is constitutional as applied to that defendant. Yan. Ito, 4 tests. Ilan ba to? 4 ba to? Hindi, mali pala yung pagkabasa ko. Number 4, tests to determine validity of a governmental regulation. So, 2 lang siya. Number 1, compelling governmental interest that also has constitutional protections such as national security or the electoral process. And number 2, all form of media, whether print or broadcast, are entitled to the broad protection of the freedom of speech and expression clause. Okay, number 5, state regulation of different types of mass media. During the election period, the COMELEC may supervise, regulate the enjoyment and utilization of all franchises and permits for the operation of transportation and other public utilities and media communication. Such supervision, regulation, shall aim to ensure equal opportunity, time and space, and the right to reply, including reasonable equal rates, therefore, for public information campaign and forums among candidates. The objective ng state regulation of different types of mass media is, of course, holding free orderly, honest, peaceful, and credible elections. GMA Network and the purchase by PLDT of a portion of the broadcasting firm did not materialize. Bakit? Why? Sabi rito, neither PLDT nor Smart is qualified to buy any broadcasting company since both companies are not 100% Filipino-owned. PLDT is 24 to 37% owned by a conglomerate owned and controlled by the Satin family of Indonesia, while Smart is a wholly owned subsidiary of PLDT. So basahin natin yung mga under the Constitution. Under the Constitution, ownership and management of mass media shall be limited to citizens of the Philippines or to corporations, cooperatives, or associations wholly owned and managed by such citizens. Congress would regulate or prohibit monopolies in commercial mass media when public interest requires. Advertising industry is regulated by law for the protection of consumers and the promotion of general welfare. Only Filipino citizens or corporations or associations, at least 70% of the capital of which is owned by such citizens, is allowed to engage in advertising industry. Participation of foreign investors in governing body of entities in such industry is limited to proportionate share in capital. All executive and managing officers of such entities must be citizens of the Philippines. So yun ang state regulation of different types of mass media. Unprotected speech. Under the jurisprudence, the Supreme Court held that slander or libel, lewd and obscene speech, as well as fighting words are not entitled to constitutional protection and may be penalized. Letter F, freedom of religion. Under the Philippine Constitution, no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof, the free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be upheld. No religious test shall be required for the exercise of civil or political rights. So under the jurisprudence, freedom of religion takes precedent over the right against impairment of contracts. Sabi pa, classifying a food product as halal is a religious function because the standards used are drawn from the Quran and Islamic beliefs. State cannot classify food as halal. Any restraint of freedom of expression on the grounds that there is clear and present danger of any substantive evil which the state has the right to prevent. Twofold aspects of religious freedom. Number one, the absolute freedom to believe as long as such is limited within the realm of thought. And number two, the freedom to act on one's belief which may be regulated. So, i-regulate mo siya, susuriin mo siya gamit ang clear and present danger test. Mere criticisms of some of the deeply held dogmas and tenets of other religions do not impose a clear and present danger. Susuriin naman natin next yung benevolent neutrality and conscientious objectors. So, under the benevolent neutrality, benevolent neutrality believes that with respect to governmental actions, accommodation of religion may be allowed, not to promote the government's favored form of religion, but to allow individuals and groups to exercise their religion without hindrance. Yung conscientious objectors naman refers to a practicing skilled health professional who refuses to provide legal and medically safe reproductive health care within the scope of his or her professional competence on the grounds that doing so is against his or her ethical or religious convictions. So, may case ito si Imbong, RH Bill. Unconstitutional lang ang some provisions ng RH Bill. Ang itinuring na unconstitutional ng Supreme Court is to require health facilities owned by religious groups to transfer. Yan, no? Allow minor parents access to modern family planning methods without consent of parents. Unconstitutional yan. And punishment of healthcare provider for failure or refusal to disseminate information regarding programs for reproductive health regardless of religion. So, itinuring yung mga provisions na yon. Yung unang-una, yung require health facilities owned by religious groups to transfer based on their religious belief, unconstitutional yon. Ayon doon sa case ni Imbong. Number 3, yan. Tests to determine the validity of governmental regulation. Under the jurisprudence, the Supreme Court held that if the exercise of said religious belief clashes with the established institutions of society and with the law, then the former must yield and give way to the latter. Yan. Letter G, liberty of abode and the right to travel. The liberty of abode and of changing the same within the limits prescribed by law shall not be impaired, except in the interest of national security, public safety, or public health, as may be provided by law. So, sa nagdaang pandemic, na-impair ang ating right to travel, pero may karapatan ng gobyernong gawin yan kasi the national security, public safety, or public health requires it. So, ang scope and limitations ng liberty of abode and liberty to travel, sabi dito, the right to travel includes the right to move within the country or to another country, but not the right to return to one's country. So, liberty to travel cannot be invoked when a law or government action does not impair the right to travel directly. Yan. Sa liberty of abode naman, upon lawful order of the court. Sabi rito, under the jurisprudence, the Supreme Court held that said indebtedness may be multiplied by millions but would not subtract an iota from the maid's fundamental right to have free choice of abode. May utang kasi yung isang kasambahay. An employment agency, regardless of the amount it may advance to a prospective employee, has absolutely no power to curtail the freedom of movement of said employee. Yan. Pag-usapan naman natin, watch list and the whole departure order. So, watch list order prohibits people from leaving the Philippines without first getting clearance from the Department of Justice. Yung whole departure order naman is a directive issued by the Secretary of the Department of Justice that prohibits individuals from leaving the Philippines. Whole departure order may be issued when, number 1, the accused, regardless of nationality, has a pending criminal case before the regional trial court. Number 2, the presence of an alien is required for a case pending litigation or before any other administrative agency of the government. Number 3, the accused needs to be held in the interest of national security, public safety, or health. So, ang hold departure order at ang watchlist order is issued by the regional trial court. Ini-issue nila yan. Pero sang-ayon yun doon sa direktiba ng Department of Justice. Letter H, the right to information. The right of the people to information on matters of public concern shall be recognized. Access to official records and to documents and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development shall be afforded the citizen subject to such limitations as may be provided by law. Ang exceptions nito, Memorandum Order on Inventory of Exceptions. Exceptions ng right to information, alinsunod dun sa inventory of exceptions. Number 1, covered by executive privilege. Yan, information covered by executive privilege. Number 2, privileged information relating to national security, defense, or international relations. Exception yan. Number 3, information concerning law enforcement and protection of public and personal safety. Number 4, information deemed confidential for the protection of the privacy of persons and certain individuals such as minors, victims of crimes, or the accused. Number 5, information disclosed to government agencies in relation to the performance of their functions or investigations conducted by them in the exercise of their administrative, regulatory, or quasi-judicial powers. Number 6, prejudicial premature disclosure. Number 7, records of proceedings deemed confidential or privileged. Number 8, matters considered confidential under banking and finance laws. And number 9, other exceptions under laws, jurisprudence, rules, and regulations. Tungo naman tayo sa eminent domain. Letter I, eminent domain. The President shall determine when, number 1, it is necessary or advantageous to exercise the power of eminent domain in behalf of the national government whenever he deems the action advisable to institute expropriation proceedings in the proper court. Scope and limitations. Punta muna tayo sa scope ng power of eminent domain. It is plenary. Wow, absolute pala ang power na yan. Under the jurisprudence, the Supreme Court held in the hands of Congress, the scope of the power is like the scope of legislative power itself, plenary. It is as broad as the scope of police power itself. It can thus reach every form of property which the state might need for public use. Ano naman ang limitations? Under the Constitution, no private property shall be taken for, number 1, public use, and number 2, without just compensation. Talakayin naman natin expropriation by the local government units. So, under the jurisprudence, a local government unit has no, ingay nila, Ulitin natin, expropriation by the local government units. Under the jurisprudence, a local government unit has no inherent power of eminent domain. Such power is essentially lodged in the legislature, although it may be validly delegated to the local government units. Under the Local Government Code, a local government unit may, through its chief executive and acting pursuant to an ordinance, exercise power of eminent domain for public use or purpose or welfare for the benefit of the poor and the landless upon payment of just compensation, provided three requisites must concur. Number one, that the power of eminent domain may not be exercised unless a valid and definite offer has been previously made to the owner and such offer was not accepted. Yan, naalala ko, in-offer ni PRRD ang isang private land or owner na pwede ba naming bilhin ang lupa mo at ibigay namin sa may hirap. Number two, that the local government unit may immediately take possession of the property upon the filing of the expropriation proceedings and upon making a deposit with the proper court of at least 15% of the fair market value of the property based on the current tax declaration of the property to be expropriated. And number three, provided finally that the amount to be paid for the expropriated property shall be determined by the proper court based on the fair market value at the time of the taking of the property. Letter J, right to association. The right of workers and employees to form, join, or assist unions, organizations, or associations for purposes of collective bargaining and registration and for mutual aid and protection. Ang limitasyon niya, the only limitation, purposes should not be contrary to law. Letter K, non-impairment of contracts. Under the jurisprudence, the Supreme Court held that to safeguard the integrity of contracts against unwarranted interference by the state, contracts as a rule should not be tampered with by subsequent laws that would change or modify the rights and obligations of the parties. Limitation, freedom to contract is not absolute. All contracts and all rights are subject to the police power of the state, and not only may regulations which affect them be established by the state, but all such regulations must be subject to change from time to time as the general well-being of the community may require, or as the circumstances may change, or as experience may demonstrate the necessity. Letter L, free access to courts and adequate legal assistance. Free access to the courts and quasi-judicial bodies and adequate legal assistance shall not be denied to any person by reason of poverty. Dalawa sa basic privilege of the accused in a criminal prosecution are the right to the assistance of counsel and the right to a preliminary examination. Letter M, rights under custodial investigation. Under the jurisprudence, the Supreme Court held that custodial investigation is the process of a mandatory issuance of invitation to a person who is investigated in connection with an offense he is suspected to have committed, without prejudice to the liability of the inviting officer for any violation of the law. Rights of a person under custodial investigation under the Constitution. Letter A, right to be informed of his right to remain silent and to have competent counsel, preferably of his own choice. If the person cannot afford the services of counsel, he must be provided with one. Letter B, no torture, force, violence, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary, excommunicado, or other similar forms of detention are prohibited. Letter E, any confession or admission in violation of this shall be inadmissible in evidence against him. Letter D, the law shall provide for penal and civil sanctions for violation of this section, as well as compensation to aid rehabilitation of victims of torture or similar practice and their families. Okay. Ano naman yung valid requisites of a valid waiver? Nag-waive siya ng kanyang rights under custodial investigation. Sabi rito, only the rights to remain silent and to counsel may be waived. The right to be informed his rights cannot be waived at any time. The waiver of the right to counsel is valid only when it is made voluntarily, in writing, and with the presence of counsel. The right to remain silent is waived when the declaration of the accused acknowledging guilt made to the police desk officer after the crime was committed. Such spontaneous acknowledgement of guilt to the police desk officer may be given in evidence against him as part of the res gestae. Yun, so spontaneous acknowledgement. Kaya naaalala ko, yung spontaneous na pag-amin ng isang akusado sa media ay tinanggap ng korte na isang pag-amin, admissible in evidence ng kanyang kasalanan. Mechanical acts not protected by the right to remain silent. Letter A, paraffin test. B, DNA test. C, examination of the physical body. D, fingerprinting. E, being asked to step on a footprint to compare foot size. And letter F, urine sample. Those are mechanical acts not protected by the right to remain silent. Letter N, rights of the accused. Under the rules of court, it is fundamental to an information to provide allegations, namely, number 1, the name of the accused. Number 2, the statute's designation of the offense. Number 3, the acts or omissions complained of that constitute the offense. Number 4, the offended party's name. Number 5, the approximate date of the offense's commission. And number 6, the place where the offense was committed. Kasi one offense, one information. Yun ang pagkakaalam ko. Punta naman tayo sa criminal due process. So, right to presumption of innocence, right to counsel, right to be informed, right to speedy trial, right to impartial trial, right to compulsory process of confrontation, right to be present. If accused unqualifiedly admits in open court that he is the person, inamin niya yung kanyang identity, trial in absentia shall be allowed. Number 2, bail. Under the Philippine Constitution, all persons are entitled to bail as a matter of right, except those charged with offenses punishable by reclusion perpetua when evidence of guilt is strong. Letter O, right to speedy trial and speedy disposition of cases. Under the jurisprudence, the Supreme Court held that the Philippine Constitution guarantees the right of a person to speedy disposition of cases, be they criminal or civil, before the courts, or administrative proceedings before quasi-judicial agencies of the government. Letter P, right against self-incrimination. Under the Philippine Constitution, no person shall be compelled to be a witness against himself. This is based on the grounds of public policy and humanity. Ano yung extent ng right to refuse? The right to refuse to take the witness stand is available only to an accused in a criminal case, but in certain administrative proceedings which are similar to adversary proceedings or partake the nature of a criminal proceeding, the Supreme Court has allowed the party to invoke the right akin to that of the accused. Right to refuse to answer an incriminatory question. Yan. Right to refuse to answer an incriminatory question can be claimed only when the specific question incriminatory in character is actually put to the witness. It does not give the witness the right to disregard a subpoena. Ano naman ang immunity of statutes? Yan, under pa rin ito ng right against self-incrimination. So, meron tayong derivative use immunity and transactional immunity. Derivative use immunity prohibits the use of the testimony of the witness or any evidence derived from it against the witness. However, it does not prevent the prosecution from presenting independent evidence against the witness. Transactional immunity, known as blanket or total immunity, grants immunity to the witness from the prosecution for an offense to which his compelled testimony relates. So under the Witness Protection Act, even if it is broader, it does not prevent the prosecution of the witness for criminal activities that are unrelated to the subject matter of the testimony. For example, A testified against Napoles. A pocketed some money, so cannot be prosecuted for malversation under the Witness Protection Act. A used the pocketed money to buy shabu. So si A may be prosecuted for the purchase of shabu. Ayan. Yan ang transactional immunity. Letter Q, rights against double jeopardy. So under the jurisprudence, the Supreme Court held that when a person is charged with an offense and the case is terminated either by acquittal or conviction or in any manner without the consent of the accused, the latter cannot again be charged with the same or identical offense. Limitations. Accused may still be subsequently charged with an offense which necessarily include the offense charged in the former complaint. So accused may still be subsequently charged with an offense which necessarily include the offense charged in the former complaint. So yun yung limitations ng rights against double jeopardy, yung deprivation of due process and finding of a grave abuse of discretion and finding of mistrial. So, pag may ganon, yun ang limitasyon. Hindi mo pwedeng i-invoke yung double jeopardy kapag merong may deprivation of due process, finding of mistrial, and grave abuse of discretion. So, in relation dito, yung doctrine of supervening event. So, doctrine of supervening event. Graver offense developed due to supervening facts. The facts constituting the graver charge became known only after the plea has been entered in the former complaint or information. Plea of guilty to a lesser offense made without consent of the prosecutor. Yun yung mga pwede mong gamitin yung doctrine of supervening event. Yan. Letter R, right against involuntary servitude. No involuntary servitude in any form shall exist except as a punishment for a crime whereof the parties shall have been duly convicted. Yan. Letter S, right against excessive fines and cruel and inhuman punishments. Under the Philippine Constitution, excessive fines shall not be imposed, nor cruel and unusual punishment inflicted. Letter T, non-imprisonment for debts. No person shall be imprisoned for debt or non-payment of a poll tax. Letter U, ex post facto laws and bills of attainder. Sabi niya, sabi sa Constitution, no ex post facto law or bill of attainder shall be enacted. Ano ang ex post facto law? The ex post facto law is to criminalize an act that was legal when it was committed. A bill of attainder is a legislative act which inflicts punishment without trial. So under the Constitution, no ex post facto law or bill of attainder shall be enacted. Tapos na tayo sa mga Bill of Rights na yan, mga basic pero hirap na hirap ako intindihin. Tungo naman tayo, discuss natin yung mga writs. Yan. So writs of habeas corpus, kalikasan, habeas data, and amparo. Writ of habeas corpus. So under the jurisprudence, the Supreme Court held that a writ of habeas corpus extends to all cases of illegal confinement or detention in which any person is deprived of his liberty or in which the rightful custody of any person is withheld from the person entitled to it. Its essential object is to inquire into all manner of involuntary restraint and to relieve a person from it if such restraint is illegal. The singular function of a petition for habeas corpus is to protect and secure the basic freedom of physical liberty. The writ of kalikasan is available against an unlawful act or omission of a public official or employee or private individual or entity involving environmental damage of such magnitude as to prejudice the life, health, or property of inhabitants in 2 or more cities or provinces. So, hindi lang basta na apektuhan ka, kailangan in 2 or more cities or provinces. The writ of kalikasan may be filed by natural and juridical persons and entities authorized by law, public organizations, NGO, on behalf of persons whose right to a balanced and healthful ecology is violated or threatened to be violated. It shall be filed at the Supreme Court or the Court of Appeals. So, kaakibat niyan, ocular inspection and production or inspection order i-issue ng either Supreme Court or the Court of Appeals. Writ of amparo is a remedy available to any person whose right to life, liberty, and security is violated or threatened with violation by an unlawful act or omission of a public official or employee or of a private individual or entity. The parties shall establish their claims by substantial evidence. Writ of amparo may be filed on any day sa kahit na anong sa regional trial court na nakakasakop sa iyo, Sandigan Bayan, the Court of Appeals, the Supreme Court, or any justice of such courts. Yan. So, writ of habeas data is a remedy available to any person whose right to life, liberty, and security is violated or threatened with violation by an unlawful act or omission of a public official or employee or of a private individual or entity in the gathering, collecting, storing of data or information regarding the person, family, home, and correspondence of the aggrieved party. So, ganun din siya sa writ of amparo. May be filed on any day sa regional trial court na may jurisdiction sa iyo, Sandigan Bayan, Court of